Hello, my name is John Milgrom. Thanks for dropping in. I'm the founder and managing partner at Milgrom Daskam. We're a Colorado-based law firm focusing on all aspects of a business's needs, from entity formation, finance, and sale, to IP protection, commercial real estate transactions, and employment concerns. We can handle pretty much all your corporate needs. We work with a broad range of businesses, from newly created a barbershop down the street to the multi-million-dollar businesses that we work with as well. We love helping folks formulate and create their dreams. We think a bit differently than your traditional law firm and recognize our place in the community. We're a certified B Corporation, a member of 1% for the Planet, and work pro bono with a number of nonprofits serving Colorado stakeholders. Today, we're going to be talking about Legal 101 for entrepreneurs. And they're going to touch on some of the most important considerations when you're thinking about starting your new business to avoid pitfalls and help make your dreams a reality. Nick Teresiano will open. He'll talk about the first step in your business journey, entity formation. Next, Laura Marmelstein will provide an overview of intellectual property and how to protect one of your most important assets. Next, I'll build on that and discuss intellectual property in the context of the internet. Then I'll pass my mic to my colleague, Alex Kamada, who will talk about the importance of privacy laws and provide you some tips on how to stay compliant in an ever-changing world of regulations. During or after our presentation, if you have a question, please feel free to email the presenter or reach out to our general contact email at info@milgromlaw.com. Thanks for attending our presentation. Thank you, Fort Collins Startup Week, for making this all possible. And thanks to all of you for taking a chance and daring to do something audacious in starting your own business. Take it away, Nick.
Thanks for the introduction, John. My name is Nick, and I am an associate attorney here at Milgrom Daskam. Focus a lot on general corporate work, real estate, and licensing. And I actually lived in Fort Collins for about 10 years before I moved to go to law school. So really happy to be here. And I'm going to be talking with you today about your choice of entity when you're starting your business. So let's go ahead and jump into the slides. So the primary purpose for you to form an entity when you've decided to start a business is because entities give you limited liability. It's really the cornerstone of American corporate law and incentivizes people to take bigger risks with their businesses. So what does limited liability actually mean? Well, if you have limited liability, it means that your business can experience a downturn or be exposed to liabilities. Say you get sued and you lose. Well, that's bad. But if you have limited liability protection, your personal car, your house, your personal bank accounts, that stuff won't go away. It won't be subject to that lawsuit. There are also entity types that do not have limited liability protection. And today we're going to cover two that do give you protection and two that do not. So first, we're going to start off with the sole proprietorship. It's the easiest entity to form. If you are holding yourself out as a business and you are selling goods or services to the public, congratulations, you are a sole proprietor. There's no ongoing compliance. There's no documents that you have to file with the state. It's really the easiest to form and the most flexible. That flexibility does come at a cost, though. Like I said, there's no liability protection. And I know I keep harping on that, but it's a really important point because, again, if you get sued in your business capacity, you could lose everything that you own in your personal capacity. That's your personal bank accounts and your home, your cars, anything that you own that isn't even tied to your business. So while they're easy to form, sole proprietorships are risky. The next entity we're going to look at is a general partnership. It's really similar to a sole proprietorship, but it's formed when two people decide to conduct business for profit. Again, there's no compliance, and there are no documents that you have to file with the state in order to form the business. Similar to a sole proprietorship, there's no liability protection, but what's different about a general partnership is that you are jointly and severally liable for the decisions that your business partner makes. So if you have a business partner and they decide to cause the business to do something that exposes it to additional liability, well, your house and your car and your personal bank accounts can be exposed to that decision, even though it's not a decision that you made. So again, this is another type of entity that is super flexible, really easy to create, but also has a lot of risk. So when we counsel our clients who are deciding to start a business, we almost always recommend that they choose a statutory entity that provides them limited liability protection. The first one of those that we are going to look at is the corporation. We've all probably heard of the corporation. It is the most popular business entity in the United States. It is formed when you submit your articles of incorporation to your Secretary of State, and then you also execute a document called your corporate bylaws. This is a document that governs how the corporation is managed internally. You keep those on file at your headquarters. You don't give them to the state. And the corporation is typically governed by a board of directors and owned by its shareholders. Legally, the board of directors owes duties of loyalty and care to the shareholders. Now, these are duties that are embedded in every state's corporate code. They're fairly inflexible, and the corporation is also taxed differently than a sole proprietorship or a general partnership. It is taxed with what we call double taxation, which means the corporation is taxed when it receives income, and then it pays its profits out to its shareholders in what are called dividends. Those shareholders are then taxed again when they receive those dividends. It's a less preferential tax treatment than what you see in a sole proprietorship or a general partnership. Importantly, though, the corporation does provide its shareholders limited liability protection. So shareholders, the owners, can only lose the amount that they've invested in the company. This is really important and protects all of your personal assets. So this slide just illustrates the idea of double taxation that we already discussed. Again, the corporation is taxed when it receives income, and then the shareholder is taxed again when it receives the profits from the corporation in the form of a dividend. Next, we're going to look at a limited liability company. Limited liability companies are, along with corporations, the most popular form of corporate entity. They're kind of the best of both worlds, from the flexibility of the sole proprietorship with the limited liability protection of the corporation. They're a somewhat new entity form that really kind of came to prominence over the last 30 years. Similar to the corporation, you have to file articles of organization with your Secretary of State and execute an internal governance document called the operating agreement. Limited liability companies are owned by their members and typically managed by managers or officers, sometimes even members. They're really flexible in how you set up the internal governance. They also don't have the less preferential tax treatment of the corporation. They feature what we call pass-through taxation. So the LLC is not taxed on the income. Only the members are taxed on it once they receive it in the form of a distribution. So LLCs sound great. They often are. There are a couple reasons why you might choose to form a corporation instead of an LLC. One, institutional investors don't typically invest in LLCs. And also it's really difficult for non-US citizens to be members in an LLC. So if you want to form a company and you expect that it's going to take lots of outside investment, or you're forming a business with someone who isn't a US citizen, the corporation might be the form that you want to go with. There are also plenty of other reasons, and we would be happy to discuss those with you given your particular circumstances or refer you to another attorney. Whether you go with a limited liability company or a corporation, you're going to have ongoing compliance, and it's really not that bad, especially for the protection that you get from forming either one of those entities. So you have to keep your personal and business finances separate. This is really, really, really important. The easiest way to lose that limited liability protection is if you start commingling funds. You start commingling your personal bank accounts, your business bank accounts, and kind of treating them the same. Never, ever, ever do that. You also have to obtain an employee identification number from the IRS. This alerts the IRS to the existence of the company, and it will treat the entity as a separate taxpayer. You also need to keep detailed written records of everything the company does. There are also certain records that you are required to keep that are in statutory law in every state. And you have to file annual documents with your Secretary of State. Those filing fees are typically around $10 a year. So we put together this quick kind of cheat sheet comparing the 4 entities that we looked at today. Again, sole proprietorships and general partnerships, they're really flexible, really easy to form, but also expose you to a lot of risk. LLCs and corporations provide you a lot of protection, but there are compliance requirements that you have to keep up with every year. Otherwise, you risk losing that protection. So again, my name is Nick. Really enjoyed presenting on entity formations with you today. If you have any questions, please feel free to reach out to my email, nick.teresiano@milgromlaw.com. And I'm going to hand it off to my associate, Laura, who's going to discuss your company's intellectual property. Take it away, Laura.
Thanks, Nick. Hi, everyone. My name is Laura Marmelstein. I'm a patent/general intellectual property attorney at Milgrom Daskam. Today, I will be providing a general overview of intellectual property. My hope is that by the end of this presentation, you'll have a better understanding of the different areas of IP and how IP is valuable for your business. Let's get started. Starting off, why is IP important to you and particularly to your business? Intellectual property increases company assets and value. For example, there can be value in establishing brand recognition where people recognize your product as a quality product and select it over your competitors. This will increase your business revenue. There can be value in having a monopoly in certain technology or business practices that keeps competitors out of your space. IP assets can be licensed for revenue or sold. According to the World Intellectual Property Organization, approximately 1/3 of the value of manufactured products sold is in intangible capital. Having IP assets also attracts investors. By adding value to your company, investors are going to be more interested. It shows that you're serious about your business and your products or services. Also, IP provides a competitive advantage. For example, you can build a reputation or keep competitors out of your space. And just from a moral perspective, it feels bad if someone steals your stuff. If you put all this time, effort, and money into building something and someone just comes and steals it, it's not going to feel great. So let's get into the core areas of IP. We have trademark, copyright, patent, and trade secret. And I'm going to touch on each of these in the next couple of slides. All right, first let's discuss trademark. What is a trademark? It's a word, phrase, slogan, symbol, design, or sound that identifies and distinguishes the source of the goods from those of others. For example, you see the shoes with the swoosh and you know that those are from Nike. We all know the M or double golden arches is McDonald's. And you can even have trademark protection for a product design or packaging. For example, we all recognize that bottle as the Coca-Cola bottle. And you can have trademarks on slogans. We all know the Subway slogan, "Eat fresh." And even sounds can be trademarked. So the NBC chimes. When do you get trademark protection? You actually acquire common law trademark rights once you begin using the mark in commerce on or in connection with your goods or services. Common law rights are limited geographically, and your rights are subordinate to senior users. So it's a first use priority system. Once you're using your trademark in commerce and using it in a source identifying manner, you can use the TM symbol on your goods or services. You can also register your trademark when you begin using the trademark in commerce, or even before use, so long as you have a bona fide intent to use the mark in commerce in the near future. Registration is recommended as it increases your legal rights. For example, you gain a legal presumption of ownership of your mark nationwide. So this expands your scope of the geographical area. Registration also gives you a constructive date of first use, so you can establish priority over others. For example, if you aren't yet using the mark, but you have a bona fide intent to use the mark in commerce, you can file and get a constructive date of first use to have priority over others. Registration also makes it more difficult for somebody to challenge your rights. This reduces the risk of having to rebrand. This is particularly important if you have your trademark on a bunch of products, because you don't want to go and have to destroy all those products to rebrand. Once registered, you can use the R registration symbol. We do recommend a search either prior to use or registration to see if there's a senior user or applicant that may prevent or limit your use or prevent you from registering your mark. To assess whether your mark infringes on the rights of others, we look at both the similarity in the mark and in the goods and services. For example, it's okay for two companies to have the same name if the goods and services are completely unrelated. For example, you have Delta for airlines and Delta for plumbing, which are two unrelated goods and services. So these two companies can coexist. Why are trademarks important for your business? They help build your brand and assure quality to customers. For example, I'm sure you all recognize these logos or trademarks as representing car companies that each carries a different measure of quality assurance. I threw Subaru in there because, well, we live in Colorado, and I'm sure we all recognize that logo as belonging to Subaru, even when it's covered in snow. And when you see that logo, you'll know that this car can handle well in the snow. And we also discussed why registration is important: to obtain greater rights, establish priority before use, and limit risk of having to rebrand. Now let's turn to copyright. What does copyright protect? Copyright protects original creative works fixed in a tangible medium. So think of artistic and literary works. When does copyright protection attach? It attaches the moment the work is created and fixed in a tangible form. Why are copyrights important? They provide a limited monopoly so you can stop others from copying or reproducing your work. Similar to trademark, you can register a copyright, which is recommended as it enables you to enforce your rights in court, and it entitles you to statutory damages and attorney's fees, which can be substantial. It's also relatively inexpensive to file for a copyright registration, so oftentimes it's worth it. Here are a few copyright best practices. It's recommended to put a copyright notice on all works you distribute to the public. This can prevent others from claiming that they are unaware the work was protected. If you're hiring others to create works, it's very important to get a contract in place before the work is done to establish that the work is a work for hire. This will protect your ownership rights in the work. Also, be careful if you are incorporating works of others. Make sure you have proper permissions and give appropriate credit. Now let's talk about patent. What does patent protect? There's actually different types of patents. Two main ones are utility and design. A utility patent protects novel and useful inventions, so how something functions. A design patent protects the ornamental design of a product, so how something looks. When do you want to file for a patent? Unlike trademark and copyright, you don't automatically get patent rights in an invention. You need to file for a patent with the US Patent and Trademark Office and wait for an allowance, which can be 2.5 to 3 years or more after filing. You can file a patent application when you have a novel invention with sufficient detail to teach another how to make and use your invention. Generally, it's better to file when you have a working prototype, after you figured out all the kinks and how everything works, but it's often a common misconception that you need a prototype to file. You can actually file before this stage. The most important timing for a patent application is to file before you publicly disclose the invention. For example, a trade show presentation, or offering the product for sale, or publishing a manuscript. In the US, there's a 1-year grace period, so you have up to a year to file for a patent application after the public disclosure, but you may lose your foreign rights because a lot of countries do not have this 1-year grace period. Why is a patent valuable? It gives you a limited monopoly. So you have 20 years for utility or 15 for design. Note, however, a patent only gives you the right to exclude others from using your invention. It does not give you a right to use. You still need to be wary of whether your technology incorporates any technology that is patented by another. A good example is someone has a patent on a stool and you have a patent on a chair. So you have a stool with a back support. You can prevent others from making and selling chairs, but you can't just go and sell your chair because you would be infringing on the stool patent. So it's a right to exclude, but not a right to use. Obviously, keeping competitors out of your space is valuable. And it's also an asset that adds value to your company. You can license your patented technology to others to gain additional revenue or sell it. Patents also attract investors. As we discussed, the added company value will be attractive to investors, and it shows you're serious about your products and that you're an innovative company. Trade secrets is the final area of IP I will discuss today. What does a trade secret protect? It protects information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent value from not being generally known, has value to others who cannot legitimately obtain the information, and is subject to reasonable efforts to maintain its secrecy. The key there is maintaining its secrecy. Some examples include a recipe, a manufacturing process, customer or contact list, pricing schedule, marketing strategies. Think of the Coca-Cola recipe, which is one of the most famous trade secrets. The benefits of a trade secret include maintaining a monopoly as long as the information remains secret. So there's no term limit like there is for patent. Keeping important information secret has competitive advantages. For example, the Coca-Cola recipe is what makes the product so special, and is why somebody would choose a Coke over another brand product like Pepsi. Of course, this can also help increase your profitability. There are some drawbacks to trade secrets. For example, when secrecy ends, the monopoly ends. So if somehow the information becomes public knowledge, you will lose your rights. It can be challenging to maintain proper secrecy as well. This can be especially problematic if the information can be reverse engineered. If it can be reverse engineered, it's probably better to look at obtaining patent protection instead. To summarize, there are 4 main categories of IP: trademark, copyright, patent, and trade secret. Trademarks protect your brand. They tell consumers the origin of the goods and services. And it's recommended to do a search to see what marks are already being used or registered and to register your mark. Copyright protects creative or literary works. It's important to contract with others involved in the creation of your works. Patent protects your inventions or technology. Utility patents are limited to 20-year monopoly, and design patents are limited to a 15-year monopoly. And it's important to file before you publicly disclose. Trade secrets allow you to protect valuable information, such as business practices and processes, so long as it's kept secret. Thanks so much for listening today. I hope you now appreciate the value of intellectual property for your business. If you have any general follow-up questions, please reach out to me. I've included my email address. And now I will leave it to John to talk to you about your online presence. Thanks.
Thanks, Laura, and thanks, Nick, as well. What great presentations. It's a pleasure to work with such an awesome team. My name is John Milgrom. I'm the founder and managing partner of Milgrom Daskam. I manage the corporate and IP groups, and it is a pleasure to be presenting at Fort Collins Startup Week this year. Building off of Laura's IP presentation, I'm going to discuss the IP implications as related to the internet in a presentation I delightfully call Spiders in the Web, Practical Tips for Managing IP and the Internet. So, why is this important? I expect most of you already know why the internet is important and why intellectual property is important, but to reinforce, intellectual property accounts for 1/3 of the world's GDP. This is growing, especially on the internet, and e-commerce is expected to account for approximately 1/4 of all retail sales this year, which is astonishing. That's really grown quite expansively and quickly. And even if a company isn't participating in retail sales over e-commerce or over the internet, you need an online presence. Every company has a website. COVID has actually really accelerated this process, as I'm sure many of you know, ordering meals off of Uber Eats. My parents, who never used to order stuff off the internet, are now ordering weekly grocery deliveries off of Instacart. And so it's much more accessible even for older populations, and it is growing rapidly. Now, the web has a unique nexus between intellectual property, platform rules, international rules, and there's kind of a web in and of itself of rules and regulations to comply with. So it's important to think about these as you set up your startup business and move forward in becoming a great success. So today we're going to talk about avoiding those spiders in the web, avoiding the common pitfalls that so many people fall prey to. I'm going to provide some practical tips. I'm going to provide some anecdotes and stories from my own experience and our clients' experience. And by the end of this, you should be able to describe your startup's needs as related to IP and the internet, and to create a plan as to how you want to manage those needs. So specifically, we're going to be talking about planting your flag, kind of carving out your space with domains, usernames, and marketplaces. We're going to be talking about playing well with others and getting appropriate permission to use the content that you want to make sure that you don't get sued for infringement. I'm going to talk about playing by the rules, so abiding by privacy policies, terms of use, having your own privacy policies and terms of use, and third parties' privacy policies, terms of use as well. And lastly, we're going to briefly touch on protecting your brand and enforcing against counterfeiters and infringers. Planting your flag. This is the first step. You've just started your business and you want to go and get your domain. Now, as Laura alluded to in her presentation, getting a trademark registration is critically important. Now, you also need to make sure you get a domain. They are not necessarily, they don't necessarily confer rights on one another. So if you have a trademark, that doesn't necessarily mean you get the domain. And if you have the domain, that doesn't necessarily mean you have a trademark. And this is pretty critically important to understand that you need both. So two practical examples that are kind of counterexamples to one another and explain the importance here. In around 2010, 2008, 2010, somewhere in there, Beyonce Knowles, Queen Bey, launched her fragrance, Beyonce. It was delightful and smells delicious. It was great. And there was a reseller of the product who went out and purchased the domain BeyonceFragrance.com. Now, Beyonce was not particularly pleased with this. She's a very famous personality. We all know her. She's a great singer, but that's just my opinion. But in any event, she wanted to get this domain back. And luckily for her, she had registered the trademark Beyonce for the fragrance. You can see the fragrance in the upper right-hand corner of the slide there. And so she registered this trademark for Beyonce. And so there's two bodies that are international bodies that kind of govern the interplay between trademark and domain disputes. And those are the World Intellectual Property Organization, or WIPO, and the International Corporation for Assigned Names and Numbers, or ICANN. And these have both existed for quite some time and kind of modernized to govern the internet and internet law. So Beyonce brought what's called a UDRP dispute to dispute the use of this name based on trademark registration to WIPO, World Intellectual Property Organization. And in order to retrieve the domain, you have to prove three elements. One is that the domain is substantially related to a valid trademark. Two is that the other party who's using the domain has no rights in that trademark. And three is that they're using that domain in bad faith. So they're trying to kind of pirate off of your trademark rights or your goodwill. Or they're holding you up. And so in relation to Beyonce's dispute, she had these registrations with the US Patent and Trademark Office. And Beyonce fragrance is clearly very closely related to Beyonce's perfume. And so because she had those registrations, she could substantiate her trademark rights. Now, famous people are sometimes deemed to have trademark rights in their name at common law, but it's very thin. And common law, you don't really want to be relying on common law to assert your rights because it's dubious. And so having that registration was critically important. The Intellectual Property Organization, WIPO, then went through the other elements. They said, does this third-party reseller have the rights to use this mark? There was no license, there was no assignment, and so they said no. And then they said, are they using it in bad faith? And they determined that they were trying to profit off of this registered trademark in Beyonce's name. And so all three elements were fulfilled. Beyonce was able to retrieve the name BeyonceFragrance.com, and the World Intellectual Property Organization forced that to go through. So the three elements were met, and it was critical that she had this trademark registration to get the domain. They informed each other even though they weren't the same thing. So now let's compare that to Meg Whitman. Meg Whitman is also very famous. For those of you who don't know, she was the CEO of eBay for around 10 years, and along with the Musks and Peter Thiel, really brought that to prominence. And in 2010, 2008, she decided to run for the governor, to be governor of California in 2010. And so she purchased up some websites like megwhitman.com and various other ones, but a third party purchased Meg Whitman for governor and Meg Whitman 2010 and various other iterations of that, and kind of squatted on them. Obviously, Meg Whitman didn't really like this, and her campaign was very upset. So they brought a UDRP dispute to the World Intellectual Property Organization. And the World Intellectual Property Organization opened up by discussing the elements. And they said, okay, the first element is this domain substantially related to a valid trademark? Now, Meg Whitman is very famous, maybe not on the same scale as Beyonce, but certainly a very famous person, has her own Wikipedia page. And so they said she's very famous, but she doesn't have any registered trademarks, and it's not applying to a particular good or service. So they said, even if there is a common law trademark right there, it's very thin, and we're not going to afford her that protection. They didn't even get to items 2 and 3 in the analysis. They just said at the onset, no registered trademark, we're not going to deal with this. And the original registrant got to keep the websites and put whatever on those domains that he wanted. Now, as you can imagine, that was pretty damaging for Meg as she ran for governor, because when people went to go visit her websites, or what they thought was her websites, there was misinformation and damaging materials on there. Now, there's other claims that could be associated with that, but it would have been a whole lot easier for Meg if she had had a registered trademark to assert ownership of this domain and to take it back. So in addition, Meg Whitman did own megwhitman.com and various other websites, but those were not deemed to confer her with a trademark registration or trademark rights in any significant capacity. So really the take home here is you need to have both. You need to own the domain and you need to own the trademark. And with a valid trademark, you may be able to get the domain back, but you also might not be able to. If that person started using the domain before you registered the trademark, the chance is very small. In Beyonce's case, luckily she had registered the trademark prior to. So once again, two things here. Get your domain and get your trademark registration. It's kind of 1A and 1B. It doesn't matter. I would say do them at the same time, and do it when you start off, and lock that up, plant your flag at the beginning. To that point, the practical things that you can do. So there's my anecdotes, and now moving on to the practical points of what you should be doing right now as the startup founder. Get all the domains that you can that are related to your company. This includes, getting the .com, the .net, the .org, and other GTLDs. There's a lot of GTLDs being rolled out right now. You might see .tv or .stream. They're basically becoming endless. So you don't need to necessarily get all of them, but do get the ones that are related to your business. And also consider getting misspellings. If somebody misspells your brand name .com, you can have that bounce over to the correct spelling of your website, and that can be very valuable as well. Otherwise, there will be pirates, if you're a successful website, who take those misspellings and snatch them up and either put unscrupulous things on there or else ask you to pay them to get those misspellings. So think about that at the onset. Additionally, think about your social media handles. Grab everything that you can, whether you're planning on using that platform or not. So Instagram, Facebook, Twitter, LinkedIn, TikTok, YouTube, anything else that you can think of where you might have media posted, grab it. Pinterest, even if you're not going to use it, because the last thing that you want is a third party to come in and take those usernames pretending they're you. And we actually have dealt with this on a couple of different occasions where a disgruntled employee who is terminated or leaves the company will snatch up the usernames that the company has not registered and start posting defamatory things about the company. So just getting that taken care of at the front end and getting all those names registered, definitely in your interest. Also, same is true of marketplaces, Amazon, eBay, Redbubble, Alibaba, wherever you might be selling stuff. Grab your username, plant your flag, carve out your space, and get that trademark registered, and you'll be in pretty good shape to start off. Also obviously consider AdWords. These items can be very easily dealt with on the front end. It's $10, $15, $20 to register a domain for a year. We're dealing with disputes now relating to trademark and domain names that the settlements range from 4 to 6 figures, and the negotiations have been proceeding for 3 years. So getting this nipped in the bud at the onset is definitely in your interest. All right, so you've got your domain, you've got your Amazon marketplace, they're all blank now, it's under construction. You got to figure out what you want to put on there. And most likely that's going to be others' content. Maybe you're a web developer and you make your own website, but more likely you're hiring somebody else to make the website for you, to provide marketing materials, to take pictures, whatever it happens to be. That intellectual property creation is originally the property of the creator and needs to be assigned or licensed to you for you to use it. Now, I have 2 cautionary tales that I want to share with you before I get into the practical tips. The first involves an optometry practice that we represent. They hired a third party to create a promotional blog for them. They didn't even have access to this blog. They didn't know the web address. They didn't know what it was. It was just 2 doctors who said, hey, these guys are marketing experts and they write blogs for a lot of optometrists and they can do one for us. So great, cool. They sign them up. It's all well and good. Everything's moving along. And then they get served with a complaint. They're being sued for $150,000, the maximum statutory limit for copyright infringement. And they have no idea what this is even about. It turns out it was related to a very innocuous picture of a contact lens case that the blogger had pulled off of a third-party website without permission and posted on their website. It was up for no more than a week. And this blogger had pulled it from a third-party website. The photographer is sort of a well-known, what's sort of the derogatory name is copyright troll. Some people don't like that name, but he has been called that before. And he monitors use of his pictures, and as soon as somebody puts them up, he sues them. And so these guys got served a complaint for $150,000. They went to the blogger, and these guys always have contracts. You have contracts with the third party who's putting your stuff into place. The blogger's contract said that the doctors were solely responsible for the content going up on the website, which made very little sense. So in the long run, the case settled, but from the doctor's perspective, they should have insisted on indemnification from the blogger, and in their future contracts, we did make sure that they had that in there. They came to us with the litigation and stuck around for future contracts, where you're putting the responsibility to get the rights onto the person who's actually creating the content. And then from the blogger's perspective, he should have been making sure that he had the rights to use this, this particular image in the way that he wanted to. It would have saved a whole ton of money and a whole ton of headache. And it's not too complicated on the front end. But I will say that there are kind of a lot of traps to fall into. So my second example actually involves our law firm. When we first started setting up our website, I have a graphic designer who we love, and she's putting together our website. And she said, hey, I want to get a few more pictures of you guys to put on the website. I have a photographer who I like. I'd like to connect you and get some photos done. I said, great, send us over the contract. And so the photographer did. And in the contract, it says you will be granted a license to use these photos strictly on your website. And, I'm an IP lawyer. I read these contracts. This is kind of my job. So I was very savvy to this. I said, you know what? I don't want just a license. I want you to assign me the entire interest to the photos so we can use them however we want them. Maybe we want to put them on our LinkedIn profile. Maybe we want to put them on the first slide of our Fort Collins Startup Week presentations. And the last slide. And so I relayed that to the graphic designer who forwarded the email onto the photographer. Now, I never had any contact with the photographer at all. The photographer emailed the graphic designer back and said, I don't grant complete assignments of rights in my photographs because copyright infringement and misuse cases are very lucrative for me. Now, let that sink in for a second. Here's a photographer who's literally saying that his business is to kind of dupe people into misusing the photographs he provides and then suing them. Needless to say, we went with a different provider, but there's a very slippery slope, and you need to be very careful to make sure that you have the rights to do what you want to do with the content that is being developed on your behalf. And that whoever is developing that content is indemnifying you to say, if they're getting it from a third party, that they're responsible for procuring those rights. So that's kind of the two anecdotes. Thinking forward, practically speaking, you want to ask yourself these questions whenever you're using any sort of generated material. One, who created it? Two, what is the basis for my use? Is it an assignment? Is it a license? Those are really the two ways. And three, how is this documented? A ton of founders that we work with go out and have a friend draw their logo, but they never have any sort of assignment. They never have anything written up. Assignments are really simple and basic. They're really short. You need to get that drawn up, because otherwise, in 5 to 10 years, when you got a $1 million company, $1 billion company, you're going to get Winklevossed, and that artist is going to come out and say, hey, I actually still have the copyright in that logo that you're using that I drew for you, and you're infringing my rights, and now you owe me a bunch of money. So just getting that stuff documented and taken care of at the onset is simple and easy. So who created it? What is the basis for my use? How is it documented? And then does my use fall within these limitations? So in the circumstance of that photographer, had I used any of the photographs he would have provided to us outside of our website, I would have fallen outside of those limitations. It would have been infringement, and he would have been able to sue me. So just be very careful to know what rights you have. And then lastly, check your third-party contracts. These poor optometrists, had no idea what was going on, and the blogger should have been responsible for it. Whoever's creating the content for you should pretty much always take onus for making sure they have the rights to that content. And that's pretty simple contractual language. Make sure you have your contracts reviewed by lawyers if you don't understand what you're signing. So now you've got your domains, you've made sure that you have the rights to put the content on there, you're throwing it on there, your website's coming together, you're about to go live. There's a couple other items that you need to make sure of. Your marketplace is about to go live, your business is about to go live, you're about to start making money. It's very exciting. It's easy to forget kind of the smaller details now. And so on your own website, on your own presence, you want to make sure you have terms of use and a privacy policy. And I'm not going to get too deep into the weeds on this because Alex is going to talk a lot more about privacy policies, but GDPR and CCPA are two new regulations related to how you collect and use data. And there's only bound to be a whole myriad more in the coming years. Colorado just rolled one out. Massachusetts has some new legislation. This is going to be a serious issue moving forward. And you need to make sure that you know, one, how your website is collecting and using data, and two, that you're informing and getting consent from your users to do that, or there can be very significant penalties. Once again, Alex will talk about that more in a significant capacity. The other thing is to make sure you're abiding by the rules of the registrar, like GoDaddy or whoever your hosting site is. That's generally pretty easy, and your designers or web managers can handle that for you as well. And then the last thing on your own site, as we mentioned before, is IP clearance. Anything that's going on there, know that you have the right to put it on there. Don't pinch copy or photos from others' websites. Make sure it's your own, or that whoever created it is assigning you the rights. There's also a ton of rules to understand and know about other sites, and these are critical as well. So Amazon, Etsy, Facebook, Instagram, they all have their own rules and regulations, and these relate to sales. So how can you sell things through these websites? What are like the return policy? Those are things you should know. I encourage you to read the terms of use. They may be boring, but they are critical to understand. Another key area where we see kind of a lot of movement now is related to endorsement. With Instagram influencers, we're now having to have the hashtag ad or paid for, and there's increased disclosure requirements. I expect this only to increase in the coming years. You think about when you watch TV and there's a drug commercial, how many disclaimers they have to have about all of the terrible things that the drug might do to you, dry mouth, nausea, vomiting, dizziness, etc. You don't see that on the internet because it's not policed as heavily, but it's still subject to the same rules. And I do think police and enforcement is going to increase significantly. So, I saw a detox diet that was proposed by Kim Kardashian on Instagram not long ago. That stuff is not going to fly for too long. And you definitely want to make sure you're ahead of the game in terms of endorsement. The last area that I see folks kind of running afoul of all the time, I guarantee I could go and find this right now, is running illegal lotteries. So you have your web presence up, you want to do some marketing on your Instagram, and you say, hey, sign up for my newsletter and enter for a chance to win one of my products. That has just created an illegal lottery that's subject to enforcement. Now, there's some elements to illegal lotteries. There's ways to get around this pretty easily by having written rules and an alternative method of entry where folks don't have to provide any sort of consideration to enter, which would mean anything of value, including their contact info for a newsletter. But it's an area that people often run afoul of. The New York Marathon was fined millions of dollars a few years ago for running afoul of this. And so it's just an area to be careful on and understand the rules. Amazon is now, the biggest player in this whole game. And they do, literally billions of dollars of sales on their storefronts a year. They have millions of users. And as a result, it's become such a big business that there are legal practices based strictly around Amazon to represent sellers in various capacities, to prevent infringement in various capacities. We do a lot of work on Amazon ourselves. And it's been really interesting kind of watching the evolution over the last 5 to 10 years as to what has happened there. So first thing to know is that Amazon makes their own rules. They have contracts for sellers that say you are submitting to our mandatory arbitration and to waive any right of class action. So what that means is that if you do have a dispute with Amazon, you're going to Seattle, you're arbitrating in front of folks who they chose to decide the outcome, and you can't join with other sellers to kind of increase your clout. You have to go one-off. And if I was Amazon's lawyers, if we were Amazon's lawyers, we would instruct them to do the exact same thing. I mean, they're playing within the rules, but it really favors Amazon at the expense of sellers. And so that means you really have to play by their rules. So Amazon was dealing with tons of infringement issues, and still are for that matter, where black hat sellers or various capacities like that would sell infringing items. Even Amazon was rumored to be selling items that infringe other folks' items as Amazon Basics. And so they were getting tons of complaints, and they didn't really know exactly how to deal with them. And their response was to create what's called a brand registry. And the brand registry enables you to have significantly increased and enhanced enforcement potential against infringers, a more rapid turnaround of complaints. But in order to register your brand on Amazon, you must have a registered trademark or patent. And there's no way around that. And trademark is really the gold standard there. So you get your registered trademark, you submit it to Amazon, and then they give you these enhanced monitoring and enforcement rights. They're currently managing over 350,000 brands on the registry. They've taken down over 6 billion suspected bad listings. This is clearly a very big area. And to the extent that you're going to be selling on Amazon, you need to get your trademark registered and you need to get your brand registered, or I guarantee you that if you're successful, you're going to be dealing with significant infringement issues. And you probably will be anyways, but you'll be much more able to deal with those issues with the brand registry than without. Another thing to consider for all your Amazon sellers is filing with a third-party auditing service. Fulfillment by Amazon or FBA is a great way to start a business. You don't have to have the brick and mortar. You don't have to deal with logistics. Those are significant pieces of overhead, and that can be mitigated by having Amazon deal with all of it for you and taking a portion of your proceeds. Very strong business solution. We have some clients who've done that, have been very successful. But Amazon's a massive company and they make mistakes. 1 to 3 out of every 100 packages they sent out are incorrect or damaged in some significant way. And that affects your brand. Getting bad product out is significant. And so having a fulfillment by Amazon or FBA auditing service to monitor your kind of shipments is really valuable. Typically what happens with these services is they'll file a claim on your behalf for the damaged products, and they only get paid if you do. So it's definitely worth looking into. So playing by the rules, Amazon is a big area to consider when you're considering playing by the rules. So we've talked about making your website, getting the content on there that's appropriate, and protecting your marketplaces, getting your domain, all that great stuff. Now you're running. And inevitably, if you're successful, you're going to find that there are people who are trying to parrot off of your success and they're infringing your products. First of all, I would say take that as a compliment that your brand is doing well. A lot of times people come to me really upset and I tell them, calm down. This means that you're successful and we'll figure it out. But the second thing is you need to enforce your rights or you can possibly lose them. So there's a few things to do to help you to enforce your rights. The first is to set up watch services with the Patent and Trademark Office to make sure that nobody else is trying to register a name that's similar to yours. The second is to set up Google alerts for your name. So anytime somebody's using it, you'll get pinged and you know what those uses are. Second item, which I mentioned before, is the Amazon brand registry. Very valuable sort of quiver or arrow to have in the quiver of protective services on the internet. Next, every website that hosts third-party content is required to have takedown procedures. This is true under the Digital Millennium Copyright Act and various other provisions of intellectual property treatises where you're able to file a takedown request and say, here's the right that's being infringed, here's how it's being infringed. We do this all the time for our clients. Need to police those. If you're not getting traction there, you can send a cease and desist. Those oftentimes have better traction if they come from a law firm threatening legal action. And then if nothing comes of that cease and desist, you can litigate as well. That's often costly, but it is very, very important to make sure you're enforcing, because if you don't enforce, you, like I said, very well can lose your rights. A great example of this is Otis Elevators used to own a brand called Escalators. It was an escalator brand, moving staircase. Now that name is genericized and we all know them as escalators. They lost all the value and the goodwill they built up in the brand name Escalator, and now it's just what everybody calls it. So yeah, if you snooze, you lose. Make sure you're enforcing your rights and preventing third parties from piggybacking on your goodwill. So the key takeaways here. We have talked about planting your flag, carving out your space, making sure you get your trademark registered, making sure your domains are all taken care of, making sure you snatch up those usernames and the appropriate places on different marketplaces. Carve out that space first and foremost, get your trademark registered, do all the behind the scenes work. It's going to save you a lot of time and headache in the future. Next, make sure you get the content rights for anything you're posting on your website. Make sure that you have a third-party contract assigning to you, and if there's a third party developing them, make sure they're indemnifying you for any sort of infringement-related activities. Next, play by the rules. That means having a terms of use and privacy policy on your own website, abiding by third policies, terms of use, understanding Amazon, getting on the brand registry, really kind of being proactive about making sure you're compliant. And lastly, enforce your rights or you will lose them. Your IP is very valuable. As a startup company in the 21st century, you're almost certainly going to have significantly valuable IP, and hopefully before too long, you're raking in the Benjamins off of this IP. However, I do want to remind you of the cautionary words of wisdom that Ben Franklin stated, which is if you fail to plan, you are planning to fail. That is no more true, or that is significantly true in the world of IP and the internet. Think about your strategy for protection. Think about how you're going to carve out your place. Think about how you're going to procure appropriate rights and make sure you're compliant. And you will in no time be making those Benjamins and developing a very successful and meaningful operation. With that, I'm going to pass the mic to my friend and colleague, Alex Kimata, who's going to talk about privacy. I, again, am John Milgrom, the managing partner here. And if you have any questions, please feel free to email me or any member of our team. We'd be glad to help. Take it away, Alex. Very glad to be sharing the stage with you.
All right. Well, thank you for that kind introduction, John. My name's Alice Kamada. I'm an associate attorney at Milgrom Daskam, and I'm here to talk about privacy and data security. And this is my jam, so I'm excited to talk about it with you guys today. So the first thing we'll talk about today is overview, kind of why this matters. You know, the two big privacy laws that are out there right now, both in California and Europe. Then third, we'll talk about Colorado privacy laws and what the obligations are for you operating in Colorado. Fourth, some quick action steps you guys can take, the low-hanging fruit to comply with these privacy laws. And finally, some other privacy laws that are out there. Now, real quick on these other privacy laws, unfortunately, I don't have enough time today to get real deep in the weeds on these, but I do want to lay them out for you just in case you work in this space, you at least know to seek legal help or to look at if you're complying or not. Now, first, talking about why this matters. So I have this clip from Parks and Rec. If you guys know, I love this show, but I think it does a really good job of talking about why privacy matters.
Hey, bro! Listen, I was trying to buy this handcrafted mahogany wood model of a B-25 Mitchell Panchito aircraft.
Aw, for me?
Don't sass me. And I went to this website and this ad popped up that said, "Hey, Ron Swanson, check out this great offer."
What's your question?
My question is, what the hell?
Like, how do they know who you are?
Yeah.
Okay. There are these things called cookies where, like, if you go to a site and buy something, it'll remember you and then create ads for other stuff you might want to buy.
So it learns information about me? Seems like an invasion of privacy.
Dude, if you think that's bad, go to Google Earth and type in your address.
So obviously, this is a little bit of an over-exaggeration, but it does bring up a really good point, right? Why does privacy matter? And really, the first point is because your customers really care about it. You know, one study in 2019 said that 97% of consumers are somewhat or very concerned about protecting their data. And in another study, 32% of customers cared about their privacy so much that they switched companies to providers that had better data handling practices or better data sharing practices. Now, second, you want to comply with privacy rules because they also help you use your data effectively. I mean, you are collecting data because you want to improve your business, hopefully. And effective privacy laws also allow you to track your customer interactions better. It allows you to form relationships with old and new customers more effectively. And it makes your business just more efficient and more cost effective. And third, so, you know, the first two were kind of the carrot. This is why it's good. The third is unfortunately kind of the stick, right? These are, there are penalties here if you don't comply. And there are penalties by governmental authorities. So you can get fined by local, state, federal, national authorities. There's private right of actions. So it means that citizens of each country or consumers of yours can sue you for violating their data rights practices. And third, they might just lose business, right? People might switch. They might deem your business to be non-compliant. You might get a bad reputation, which will harm your future business, any and all of the above. So first, we're going to look at the two big privacy laws. And the first one is, right, General Data Protection Regulation, or GDPR, which is in Europe. The second is California Consumer Privacy Act, CCPA, which is in California. And before I dive too deeply here, I do want to say that even if you're not in Europe, even if you're not in California, these still really matter. And the reason is because this is kind of the general direction that privacy is going. Privacy is going to look a lot like this, we expect, for a lot of states, right? So maybe you're operating in Texas, or maybe you're operating in Wyoming right now, and the privacy laws are not as intense as this, but this is where we expect them to go. These two privacy laws are very influential right now. And in addition to that, they're just really good data handling practices generally. They're not super onerous. You should generally be looking at this. And the last thing to say is if you start doing this now, right, if you start enacting good data handling practices, you know, learning where your data is coming from, cataloging it correctly, protecting it safely, that when these, you know, come into full force, you know, 2, 3, 4 years from now, you're ready to rock and roll. It's much easier to get started now than to set up a system and then have to go back and recatalog, 10,000 consumers or customers that you have. So we really suggest, starting now, looking at this and starting to implement just good data handling practices generally. But getting into this, right? So the first thing I do want to say is that GDPR, like I said before, applies to people in Europe. So, that's if you're marketing in Europe, if you have people living in Europe who are your customers, GDPR is likely to apply to you. CCPA applies to businesses doing business in California and also meeting one of these three prongs. So first, either, you're a bigger business, you have gross revenue over 25 million per year, or you have a lot of consumers, so you have over 50,000 consumer kind of data sets, or you derive over 50% or more of your revenue from California consumers' personal information. Now, second, looking at protected information, both these laws treat this very similarly. This is kind of the standard practice for a lot of states, right? Protected information is really kind of any personal data that relates to, identifies, could reasonably identify a consumer. So, we're talking about names, we're talking about addresses, phone numbers, biometric data, right? These all can help identify you. And so they're considered personal information under these regimes. Now, third, privacy notices. Both of these are also very similar. They require a detailed privacy notice that's, easy to read, easy to access, and kind of simply tells you what you need to know about how you're collecting data, how you're using data, how you're transferring data. Third, security measures. So GDPR requires reasonable and appropriate security measures, basically meaning that it's reasonable for the size of your business, reasonable for the sensitivity of the data you're collecting. So, if you're a bigger business, you're probably expected to have higher security measures. If you have more sensitive data, similarly, you're expected to have higher security measures. Now, California doesn't have that same requirement, but it does say that if there's a data breach and you don't have reasonable security measures, people can sue you. Now, looking at data subject requests. So data subject requests, you may be familiar with, they're basically consumers' rights to access the data they give you, right? So consumer gives you their name, gives you their credit card information. Later, they want to know kind of what data you have on them. They can give you a data subject request to either access the data or correct the data. And these are becoming much more common. So in GDPR regime, consumer has a right to access, has a right to transfer the data, has a right to ask you to delete the data or correct data if you have incorrect data or incomplete data. For California, it's very similar. They have a right to access data, to transfer data, or to request that you delete data. And finally, what do the penalties look like under this regime? So GDPR and CCPA both have fairly stiff penalties. In GDPR's case, the penalties can be really high for a government entity. So administrative fines here can be a higher of 20 million euros or 4% of your annual global revenue, which is pretty significant. There's also a potential private right of action. So consumers can sue you if you misuse their data. For California, it's the $2,500 per violation or $7,500 if it's an intentional violation. And there's also a private right of action. So moving onward, right? Colorado privacy laws. So again, Colorado's is not as onerous yet as California's or as Europe's, but Colorado does have privacy laws in existence, and you should know about them and comply with them. So the first thing to know is that there are laws that apply to personally identifiable information, or PII as it's called. Essentially, PII is anything that could reasonably identify you, right? So it includes passwords, your identification card, biometric data, your identification numbers, financial account numbers, really sensitive, kind of any sensitive information probably is included under PII. And again, there are security measures here. So you are required to implement, maintain reasonable security procedures and practices that are appropriate for the type of personal information you have and the nature and size of the business and its operations. Again, this just means, right, that you should be taking reasonable measures depending on what privacy information you have from a customer and how big, how sophisticated you are. So again, the bigger you are, more likely the more security measures you should be taking. And again, the more sensitive data you have, right, the more security measures you should be taking. Also, you are required kind of downstream to make sure that your vendors, your suppliers are also complying with this. So you're required to ensure that your service providers, your vendors, they also have reasonable security measures to protect the data you give them as well. And finally, there's kind of a disposal rule for this, right? So if you have electronic paper documents that contain PII, you need to have a written policy on how you're going to dispose of it, how to destroy the PII when you no longer need it. This one I know comes a little bit of a shock to a lot of people. People don't realize that this exists, but you should have a plan about how you're going to get rid of data, when you're getting rid of data, and at what point, right, you don't need data anymore. Now, moving on to personal information. Personal information is defined a little bit differently than PII. It includes kind of unencrypted or unredacted data that either, number one, contains your name in some form, so your first name or first initial and last name, plus any one of the following, so social security number, ID number, medical information, biometric information. It also includes kind of username combined with password or security question, and kind of, or any financial information. So account number, credit card number, security code, or password, right? And this applies to security breaches. So if there is a breach of personal information, right, it goes to people who are not authorized to see the personal information. You're required to conduct an investigation and notify those residents whose security was breached within 30 days of that breach. Also, if this breach includes more than 500 Colorado residents, you need to let the Attorney General know. So then this will get out there, right? So this is a fairly substantial obligation, all the more reason why to have reasonable security measures to make sure this never happens. But what are the action steps, right? What is the low-hanging fruit? So there are a lot of compliance measures out there, right? And if you are operating in this space or you have sensitive information, again, I would highly recommend you talk to a lawyer, consult with somebody, talk to someone who knows what they're doing. But right now, the low-hanging fruit for you are kind of four things, right? So first, everyone here operating a business, starting a business, should have a privacy policy, right? And it should be simple, right? You should talk about what data you're collecting, how you're using it, how users can kind of amend withdraw consent, right? So like, I'm letting you use my credit card information to purchase this, but if you no longer want me to run your credit card, how do you withdraw consent, right? Or you're giving me, your name and address, I can send you stuff, but you no longer want me to use it. How do you withdraw consent? Should talk about these things. I do want to emphasize here, right? Like, don't collect data that you're not using. I can't tell you how many times I talk to maybe like app developers, right? And they collect like gender information, for example, when you sign up. And I say, why do you need gender information to play this Tetris game? And they say, I don't know. I just included it just because I might want it, right? That's like a terrible, terrible reason to collect information. You should only collect information you're going to use, right? So it's acceptable to collect name, address, email, right? If you need to verify who they are. It's good to collect maybe, phone number if you need to call them or you need to contact them. But, if you're collecting, gender or biometric information or even location data and you don't need it, don't collect it. I can't emphasize that enough. And finally, kind of, when you get this privacy policy online, you should post it online or kind of near your services, somewhere easily accessible so your customers can see it. Moving on, cookie policy. This was referenced in the Park and Recs YouTube video, but basically, if your website's using cookies, if you're monitoring consumers or customers to see how they're using your website, how they're using your services, they should consent to this. And there are easy programs out there online that you can pay for that'll analyze your website or API or whatever you're using to see what cookies you are, generate kind of a cookie banner, which I'm sure you've seen everywhere, basically that pop-up that says, you consent to these cookies, and will help you comply with this. Third, again, there's a disposal policy. So like I said, you should be thinking about how you're getting rid of data, what that looks like. So come up with a disposal policy about how you're getting rid of data and figure out, right, like when do you not need data anymore, how you're going to delete it, right? How you're going to delete it in ways that will not allow it to be shared with the public. So, if you have printed out confidential information, don't throw it in the trash, shred it. If you have it on computers, right, delete it permanently. Don't let people, have copies hanging around their phone or somewhere else. And kind of fourth, security measures. You should be thinking about how you're protecting consumers' data, right? They are trusting you with their personal information. As we previously said, this is really important to consumers. There's a lot of obligations here. You should really think about how you're protecting this. So encrypt and secure your data, especially if you have sensitive data, right? Like gender information. For some reason, you have kind of health information, sexual orientation information for some reason, right? Like those are the really sensitive data. And you should take special note where you're storing it, right? Are you encrypting it? Who has access to it? If it's printed out copies, keep it in a locked drawer. All these things, if you have a bring your own computer to work policy, right? Can these people download this data on the computer and take it home with them? Probably not. Just really think through that process about how you're protecting the information. And then finally, just know that if you have a breach, you need to report it. You need to conduct an investigation. You should probably hire a consultant or someone who knows what they're doing if that ever happens, but just know there is an obligation there. And finally, talking about other privacy laws. So, again, like I said, I don't have a ton of time. Unfortunately, I'm up against the amount of my time I have to talk today. So I can't really get too much into this. But I do want to just highlight these for you because privacy laws are really expansive, right? It's not just what I talked about today. There are tons of very specialized privacy laws for specialized fields. And I just want to make you aware of these. If you're working in any of these fields, you should seek consultant, seek legal help to make sure you're complying appropriately. So the first and maybe well-known one is HIPAA and HITECH. It's for Health Information Portability and Accountability Act. Basically, if you have health information, if you're talking, with hospitals, you're talking about, biometric data with people, you should make sure you're complying with this law or see at least if this law applies to you. Second is FERPA, or the Family Education Rights and Privacy Act. If you're dealing with student records, students have special rights to access and restrict your access to their records. So you should make sure that you're complying here. There's Gramm-Leach-Bliley Act, or GLBA, as it's commonly referred to. This is for financial institutions. One thing to note here, right, is financial institutions is defined broadly. So usually when I say financial institutions, people think of banks, but this is a really broad definition. So it applies to, insurance companies, for example, credit reporting companies sometimes, for example, as well. So if you're dealing anything in the financial field, you should definitely check to make sure to see if this applies to you, and if it does, to make sure you're complying. Fourth is the CAN-SPAM Act, right? So this was passed in the 90s after people started getting tons of telemarketing and spam emails, calls all the time. Essentially, it restricts or highly regulates, I guess, the ability for you to telemarket or randomly cold call people. It, has specific times when you can call, it has who you can call, no call lists, etc. So if you are doing telemarketing, cold calling, any of that stuff, do make sure you look at this law and make sure you're complying. Fifth is Fair Credit Reporting Act. This is really if you're doing background checks on employees, you're doing credit card applications or anything where credit's kind of necessary, insurance maybe, for example. There are laws on how you access people's credit reports or background reports. And especially if you give them kind of adverse decisions, if you turn them down for some reason, there's a highly regulated process on how you have to present that information. And finally, but not last at all for any of the privacy laws, there's COPA, which is the Children's Online Privacy Protection Act. Basically, if you're collecting children's information, there is highly regulated ways that you need to make sure you're getting appropriate consent to collect their information and using their information appropriately. That is the presentation. Hopefully it was helpful for you. We went through an overview of kind of why this is important, kind of the two big laws, what Colorado's laws look like, some action steps for you, and some other general privacy laws that are out there. If you have any questions at all about this, I'm happy to answer them. Like I said before, I love talking about privacy, obviously. Happy to answer any questions at all. My name is Alex Kamada, and the email address is right here, alex.kamada@milgromlaw.com. And finally, just wanted to thank Fort Collins Startup Week and Techstars, obviously, for sponsoring it. It's been a great experience. And again, if you have any questions on any of the previous topics as well, we've thrown everyone's name and email up here. So you can contact us. All right, well, thank you very much.